I'm Derek Johnson with Tatango.com. I'm here at Innovista Law, home of the TCPA Defense Force, and I'm sitting with attorney David Carter, and we're discussing TCPA, Telephone Consumer Protection Act. So let's discuss, what is the Telephone Consumer Protection Act?
Sure. So the Telephone Consumer Protection Act was adopted by Congress in 1991. It's a series of rules and regulations that have been implemented by the Federal Communications Commission, and it really governs issues around robocalling, telemarketing, and of course text messaging, one of the topics that we're going to talk more about. And the Telephone Consumer Protection Act sets up the requirements for companies and brands across the country to know when they can use these technologies to reach their consumers, to market their services, or in some instances to just provide information to them. It may not be specifically a marketing message, but there's different rules and regulations that apply.
Like package alerts and healthcare type messages?
Absolutely.
Okay.
So we have those, we have messages from nonprofits, and many industries have sort of specific exceptions or carve-outs. Other industries, it depends on the type of message that's being sent, and so there's a whole host of rules and regulations around this that govern the use of these advanced technologies.
And this is law, correct?
This is law, right?
Okay.
It was adopted by Congress. The FCC over the years has adopted a series of different orders or interpretations.
Okay.
And so it's an area where there's actually pretty frequently a development or a change in the law. And those changes are usually not happening on the congressional level. They're happening within the agency, within the administrative branch, and they're sort of making modifications. Again, as if you think about 1991, right?
Yeah.
Long time ago.
It was a long time ago.
We did not have cell phones at the ready. We
Yep.
didn't have text messaging that hadn't even been invented.
Yep.
So a lot of these changes that are occurring are because technology changes. And as technology changes, typically it's been the Federal Communications Commission that has looked at how does the TCPA apply to these new technologies? What are the consumer expectations? And ultimately at the core of the TCPA is an attempt to balance the commercial speech of companies to reach consumers with the right of consumers to privacy. And so if you think about the driving force behind the Telephone Consumer Protection Act, 1991 is a time when people were very upset about going home and having their dinner interrupted because people were calling them on their landline telephones. Right?
Yeah, I don't even have a landline anymore, but I can imagine the pain.
Yeah, less and less people have landlines, but that was the context in which Congress adopted it. At the same time, they created what a lot of people are aware of and refer to as the do not call list, right? And so where you can say, don't call my house without permission to market to me. And so that's the environment in which it was adopted. And since that time in 2017, we have a lot of different technologies, a lot of different ways in which people communicate. So the Federal Communications Commission has consistently reinterpreted or reevaluated.
So like updated almost.
Correct.
Kind of the initial law.
Correct.
Now, why should brands care? I know it's the law, but so is 55 on the highway. What are the punishments for violating the law?
Yeah, so unlike a little speeding ticket, which you might pay online, the Telephone Consumer Protection Act comes with pretty severe penalties.
Okay.
And so if you make an unauthorized call that doesn't comply with the requirements, or in your case, and your customer sent text messages without the appropriate levels of consent, then the law imposes minimum statutory damages of $500 per message.
Per text message
Per
or
text
call
message.
or whatever.
Exactly.
Wow, okay.
And then up to $1,500 for plaintiffs if there's some willful or knowing violation of the law.
Wow.
And so what you have is also 1991, Congress adopts the TCPA, and they have in their minds a sense of small claims court, right? And they think that a single plaintiff that's getting these unwanted calls will go into small claims court and say, I want my $500 because you've been bothering me, right? And that will be a sufficient deterrent. What's happened, though, is that most of these cases have actually been brought as large class action cases.
Okay.
And so you have class action plaintiffs getting together and bringing claims against companies and saying they violated the TCPA and seeking $500 per message.
Per person.
Per person.
Times how many messages they've received.
Exactly. And suddenly you're talking about millions, hundreds of millions of dollars of potential exposure for companies. And a lot of it turning on very fine details of the TCPA, interpretations, not necessarily common sense things that people would understand. And
like just receiving a call at home, it's not that easy anymore. There's a lot of stipulations as to what needs to be included, disclosed, things of that nature.
Exactly.
Okay.
And then you couple with that a lot of the newer requirements or obligations are sort of packed in these long FCC orders that most people don't spend their leisure reading.
Because it's changing all the time, so it's updating, evolving. It's not, you can't read the original 1991 law and say, I know everything now.
Correct, yeah. You can't even read the 2005 version. And,
so constantly updating.
Constantly updating.
Okay.
Absolutely.
One question I get is, in the Telephone Consumer Protection Act, 1991, the law, I guess, it doesn't say text messaging anywhere.
Right.
It doesn't say SMS, doesn't mention anything.
Didn't exist really at the time, right?
So, but can you clear this up for us? It does apply to text messaging now.
That's right. So again, that's a great example of an FCC interpretation. So 1991, Congress did not think about the future of text messaging when they were writing the TCPA. And so the extension of the TCPA to text messages has been a result of an interpretation by the Federal Communications Commission, which said that a text message is the equivalent of a call. And so the language in the statute is call. The FCC has said text message, that's pretty much a call. And so that's how we've gotten to where we are today, where the text messages are clearly within the confines of the TCPA.
So speaking of text messages, how does a brand remain compliant just for text message marketing, let's say, because we have a lot of marketers, and there's other things like informational messages and then types of other messages for the healthcare and nonprofits. But let's focus on marketing and sales, because I think that's where the majority of text messages are coming from. How does a brand that wants to send marketing and sales text messages to their customers remain compliant under the current law, what it is right now, for the TCPA?
Sure. So if you're going to send marketing and text messages to your customers, the most important thing that you're going to have to be focused on is getting the appropriate level of consent from the customer before you start messaging them. And so what is required for that is written opt-in or written consent. And so there's a series of different ways in which you could go about achieving written consent, even though it sounds like a pretty easy to understand term.
But it is kind of written consent, for me, means you have to write down your consent, like you have to sign a piece of paper. That's not the case anymore.
That's right. So, I mean, that's certainly one way that people could do it. You could literally have pen and paper out and people could sign up and agree to give consent. But you can also gain consent by having people, for example, opt in through texting to a short code. And then
like a digital consent.
A digital consent, right? And so the law is very clear on this, that consent can be given through digital means. And so it could be texting to a short code, having people sign up on a website
form or something.
Exactly. So there's a series of different ways. And in each of these methods, the important part to understand is that if it's ever challenged, whether or not the consumer did give their consent, it'll be up to the company to produce evidence of that. And so as companies are thinking about how they would go about getting and recording consent, they should be making sure that they're keeping a record of it and that they have a good method for producing that record if there's ever a challenge.
So consent is key, and before you start text messaging them. This is not, I can just buy phone numbers and ask for their consent, right?
This is not like the old days where people would buy like email lists and start blasting emails out to people and hoping that they didn't mind. Here, when you're talking about text messaging and TCPA, Congress, the FCC, they're really worried about the fact that consumers may incur a charge when they get those text messages. They think about the fact that people may be sitting in meetings. And
it's annoying.
So they really want to make sure that messages are only reaching people that have previously said yes, like you have a permission. I want to receive your marketing text messages, and really, when you get into looking at consent, they should have some awareness of how frequently you might be messaging them, things like that.
What they're going to be messaging, what they're opting in for, essentially.
Exactly.
Because really, isn't the FCC and the TCPA, it's not to really hurt anybody, it's to protect consumers.
That's right. I mean, it's really driven by the desire for consumers to be able to maintain some sense of privacy. Not have intrusions in their life unwanted. And so that's the kind of primary driver around the TCPA.
So it sounds like a good thing for consumers. It's just businesses because it's ever changing, you have to stay up to date on it and knowledgeable about it,
Right.
so that you don't get in trouble, when you text message your consumers.
Yeah, it's a delicate balance, and I think everyone can debate whether the balance is too shifted in one direction or the other. But that's essentially what they're trying to do, is they're trying to create that balance of protecting consumers while still giving companies the opportunity and the ability to reach them through
To message their customers,
Right.
the things that they want, obviously.
Exactly.
Now, there's one other thing. If you're opting into a text messaging campaign, consumers usually see consent is not a condition of purchase.
Right.
So first you have to get their consent, and then there's this phrase. Can you explain what that phrase means?
Yeah, so that's another example, as we were talking earlier, about an FCC interpretation, right?
Okay.
Congress did not create that requirement at any point in time, 1991 or forward. That is a requirement that the FCC has imposed.
Oh, so it's been added.
It's been added.
Okay,
right?
so if you look at the original 1991, that's not in there.
That's not in there.
Okay,
that's
so
not in
that
there.
shows you have to always be constantly
Yes.
aware of what's changing.
Yeah, and it's an interesting requirement that you have to make that affirmative representation to consumers and let them know that they do not have to give their consent in order to be able to purchase your good or service.
Okay.
And what was happening and what the FCC was concerned about there is that people would present a sales contract, right? Maybe you were buying a car, for example. And you get this sales contract, it's this really lengthy document which virtually no one reads.
Yeah.
And in the middle of that contract there somewhere would be this requirement that said, if you're going to buy my car, you have to consent to me.
There's
sending
no other
you
option.
texts. Right.
Yeah, okay.
And you can't say, well, no, I want the car without the text message.
Cross that
Right.
piece off or something.
And so the FCC has said, look, you can't force people in, to buying your car, your mobile phone, or whatever, and giving up their right to privacy at the same time. You have to allow them to make the purchase without having given up that right to say, I don't want your messages.
Sounds like it, again, just protects the consumer, because that would just be a horrible thing for consumers.
Right.
Okay.
And I think that's, again, it's about trying to get to a place where consumers know that they're actually going to start receiving these messages, right?
Okay.
And so if it's sort of in the contract and you don't have a way to avoid it, then you're not really voluntarily consenting, is what I guess.
It's kind of like hidden in there almost.
Right.
Is there anything else text message marketers need to know about compliance with the TCPA, or anything else that just needs to be kind of stated, for our viewers?
Well, I think that it's important for people, if they're coming to text message marketing for the first time, right, to work with people that understand the landscape, because as we've talked, the Telephone Consumer Protection Act is a part of the overall landscape. It's
Correct.
the area I focus on, the legal requirements that people have to comply with. But there isn't a larger ecosystem out there, as you know, working with the mobile carriers, keeping them happy. There's groups like CTIA
yeah.
and others. And so you have to understand kind of the whole landscape to make sure that as you're planning your campaigns to reach your consumers, that you're both complying with the explicit direct requirements of the TCPA.
Because that's the law.
That's the law.
Yep.
You don't have a lot of room for deviation there. But there's then all these other sorts of like best practices, things that maybe help you to maintain good relationships with your customers. And so having people that are familiar with that space kind of help you navigate each of those areas, I think is really important to someone that's coming to text message marketing for the first time.
So it seems like a team effort. You can't just go find an SMS expert and they'll know everything. Right. Essentially, you got to bring in TCPA experts, people that the software like Tatango, people that know CTIA. You got to bring in the brand, obviously, their corporate counsel, figure out all their objectives. This is not just a single person kind of managing the whole show. This really is a team effort, it sounds like.
Yeah, I think so. I mean, I think that brands that are coming to the space for the first time in particular get a lot of benefit out of working with a software vendor that's going to help send the messages out, that has good relationships with legal counsel, that can help them navigate those things as a team, really.
Yeah, no, that sounds good. Perfect. So that answers the question, what is the TCPA, the Telephone Consumer Protection Act, and most importantly, how does it apply to text message marketing? Again, my name is Derek Johnson with Tatango.com. I'm here with David Carter from Innovista Law and the TCPA Defense Force. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comments section below.